navigate the government support. So for now, I'll hand back over to you, Rob, and look forward to catching up with you all at the next event. Rob, I think you're still on mute.
Yeah, okay, sorry, Jen. Thanks very much for that. So we're now going to head over to Paul Chamberlain, who is Head of Employment at JMW. There's a lot of questions, as you would expect, being asked at the moment currently about furloughing, job retention, holiday pay, etc. So I'm sure there'll be a lot of questions for Paul to field. So Paul, if you're able to unmute your mic, please, and just give us a overview, really, I guess, of what you're currently speaking to your clients on, where are the main areas that you're helping, and also there's a lot of regular government's updates on a daily, weekly basis. So perhaps if you could comment on some of those. If any of you would like to ask any questions throughout, there's a chat box function at the bottom. So please, if you could click on that, type a question in there, and then I'll be monitoring the questions as we go along, and I'll raise the question at the appropriate time. Over to you, Paul. Thank you very much.
Thanks very much, Rob. Good morning, everybody. Thanks for the invitation to speak. So you're absolutely right. This is a very interesting, novel and new scheme that the government's introduced. I think it might be worthwhile just making a couple of basic points before we delve into the detail. Everyone's caught up with this word furlough. It seems to have entered common parlance over the last few weeks. It basically just means a leave of absence. And as an employment lawyer, there are two aspects to this furlough arrangement that the government has introduced. The first is the legal aspect, and the legal aspect is that this is broadly layoff. And for those of you who are running businesses, you'll know what layoff is. It's very rarely used, but it has been used in the past in manufacturing industry in particular, where there's been downturns in orders and maybe seasonal activity, and the employers decided that rather than terminate the contractual arrangement with the worker and make the worker redundant, they've wanted to keep that relationship in existence so that if things then do turn a corner later on, they can immediately bring people back from layoff to start work again, basically where they left off. So the starting point as an employment lawyer is to just make sure everybody understands that this is not new as a legal concept. The new bit is the government subsidy, the Coronavirus Job Retention Scheme, as it's been called. Because what the government have said is, look, this is no one's fault. This has happened because of the current situation we find ourselves in. We want to try and incentivize employers to keep hold of their workforce so that if things do turn a corner later on, instead of everybody having to go through the pain of recruitment, they can simply turn the tap back on, bring the workers back in. And there are no dismissals, there are no statutory redundancy payments being made. It's all done with a view to trying to persuade employers to keep their staff on the contractual hook, as it were. They're offering a significant financial incentive to do that. It's broadly 80% of the usual monthly wage cost for the employees, which is capped at £2,500 a month. And when people ask me about the government scheme and ask me about furlough, is it lawful, is it unlawful, you've got to recognise that the government scheme isn't law. There's been no act of parliament passed in relation to the government scheme. So all we get with the government scheme is a series of guidance notes. And I think we're now on the third iteration of those guidance notes. There was a further revision made on the 9th of April. So just around the bank holiday weekend. Didn't really add a great deal to what we already knew. And in particular, it didn't deal with a couple of existing questions, which are long-term questions, which haven't yet been properly answered. So I wanted to make the point at the start by saying the legal situation you find yourselves in as an employer is that you're laying off staff temporarily. That's broadly what this looks like. The government scheme is simply a subsidy to help you with the cost of that process, where you're paying people effectively to stay at home and do no work. So given that the legal issue is one of layoff, you've got to understand that you can't just lay people off willy-nilly without it having some impact on the contractual situation. What you look for initially is whether or not you've got a clause in your contract that allows you to lay someone off. Some contracts do, but I have to say it's not a usual provision that's drafted when contracts are created. If you've got a layoff clause, that's great. You can use the layoff clause to lay people off and you won't then be in breach of contract. If you haven't got a layoff clause, then you have to agree furlough. You have to agree this temporary layoff with your employees. Now, it has to be said, this isn't like any normal contractual variation in usual times, where an employer might find it difficult to persuade an employee to agree to a change in their terms and conditions of employment. What we've tended to find over the last few weeks is that virtually all employees have said they are happy to be furloughed, so they've agreed to the contractual variation, because they've recognised that the employer is doing it with a view to trying to avoid making redundancies. So it is fair to say that most employees are not treating this as a normal contractual variation situation. They seem to be exceptionally grateful that the employers decided to go down this route rather than laying them off permanently and making them redundant. But technically speaking, their consent is required, and both the government scheme and indeed employment law generally dictates that where you reach an agreement of that kind to vary their employment contract, you should have it reduced to writing. You should have a piece of paper that sets it out and that makes it very clear that it's all been agreed. If you can do that, then you've ticked all the legal boxes and there ought not to be any issues. I'll just throw one curveball in at this point, which is that if you're dealing with a number of employees who are being furloughed and a number of employees whose terms and conditions have to be changed as a consequence, then you might find yourself in collective consultation territory, bizarrely collective redundancy consultation territory, where you're changing or attempting to change more than 20 people's contracts to put them on furlough. There might be technically a trigger to collectively consult with trade union or other collective representatives. But I won't say very much more about that at this stage. If anybody finds themselves in that situation, then you do need to take some separate advice, and I'll be happy to either field a call after this or deal with it at a later stage. So Rob, you very kindly asked me to comment on some of the issues that seem to crop up on a regular basis. I'm assuming most people on this call will know what the broad scope of the government scheme looks like. We've had some clarification over the last week, certainly in the update on the 9th of April, around one or two areas. One area that we still don't have any clarification in relation to, and there are as many views on this topic out there as there are employment lawyers, is whether or not holidays continue to accrue during any period of furlough. Now, my firm does quite a lot of work in the recruitment agency space, where you're dealing with temps who are eligible, by the way, to be furloughed, whether they're employed temps or temps on contracts for services. And there's a big question mark over how you calculate any holiday entitlement that they might accrue during the course of any furlough period, when they might not be normally on assignment guaranteed any hours. I think the starting point that we've adopted at JMW, following basic principles, is that everyone's entitled, all workers are entitled to 5.6 weeks paid annual leave each year. And given that the contract between the worker and the employer here is not ending, it's continuing. It might look very different to the way it would normally look when people are fully employed, but nonetheless, there is an ongoing contractual relationship between the employer and the worker here. I think our view, and it's the view that I think most people subscribe to, is that holidays continue to accrue during the furlough period. And whilst these aren't exactly, they're not exactly analogous situations, there are other instances of leave where holidays continue to accrue when the person's absent from work. If you think about sick leave, someone's off work with a sickness or underlying illness, there's no question that their annual leave continues to accrue whilst they're off sick. They're not working for you, they're receiving possibly just a statutory payment, but their annual leave continues to accrue whilst they're on sick leave. Similarly, if you think about pregnant women who go off on maternity leave, it's absolutely clear that their annual leave continues to accrue whilst they're on maternity leave. So whilst they're not identical situations, I think they are analogous enough to be able to say there's no reason why that general principle shouldn't apply to this new type of furlough arrangement that we now find ourselves facing. But there's a lot of other information out there. ACAS have issued a very interesting note. They issued it just before the bank holiday weekend, where they took a slightly different view on holidays, and certainly bank holidays. They've also taken a slightly different view in relation to whether or not someone can go on holiday or take annual leave whilst they're furloughed, and whether or not that breaks the furlough period. And we're getting a bit technical here, but that's relevant because those of you who've read the scheme rules will have noticed that you have to be furloughed for a minimum of 3 weeks before you can make a claim, or before your employer can make a claim for the subsidy under the scheme. So there's a question mark over whether or not those 3 weeks, and they've got to be 3 continuous weeks, by the way, not three weeks in total, 3 continuous weeks, whether that 3 continuous week period is broken by any other event. So of course, if someone was able to take annual leave during that 3-week furlough period, there's a question mark over whether that breaks furlough, and whether or not you then have to start again from zero when you get back to work after that annual leave period. Our view is that you can't be on 2 types of leave at the same time. And indeed, the government note itself makes the point that you can't be receiving statutory sick pay or be regarded as absent from work on the grounds of ill health and on furlough at the same time. The 2 periods are mutually exclusive. So it strikes me that the same principle has to apply in relation to annual leave. You can't be on furlough and on annual leave at the same time. You're either on one or the other. And if you're on one or the other, then the risk is that annual leave will then break the furlough period, the 3 weeks continuous period, and that may put you in difficulties as an employer in claiming the grant back from the government scheme. So I make all of those points really in the context of saying it isn't clear. The government may be reluctant to say anything about paid annual leave in the guidance note, because it may say, well, we've made it clear in the guidance note that everyone's employee rights continue during the period of furlough, and by saying that we also mean the right to paid annual leave under the working time regulations. But I know that a number of trade bodies, representative bodies, including the Recruitment and Employment Confederation, TEAM, the Employment Agents Movement, and others, have made representations to the government and have asked them to commit to explaining their position on annual leave during furlough. So that's one tricky area which has cropped up, where we don't appear to have very much guidance. In contrast, another tricky area that cropped up during the course of the last 2 or 3 weeks was the question as to whether or not people could work in a second job whilst they were furloughed in their first job. And the government have tied their colours very firmly to the mast there and said, yes, that is perfectly possible. The guidance says if you're furloughed, you mustn't do any work for the organisation that's furloughed you. Which means, or which at least begged the question initially, well, what does that mean? Does that mean if you've been furloughed by organisation 1, but you have a second job, that you're effectively precluded from continuing with that second job if that second employer doesn't need to put any of its employees on furlough. The implication appeared to be that that was perfectly legitimate. The government have now said, absolutely, that is perfectly legitimate. So you can have a situation where someone's furloughed from a full-time position, is receiving the grant, or is receiving pay, which is then reclaimed as the grant by the employer, but then goes off and effectively, conceivably, could take on another full-time role with a second employer and be receiving a second salary as a consequence. There is nothing unlawful or nothing contrary to the scheme rules if someone were to do that. And of course, in the economy generally, we all know this because we've all seen it. Lots of people do have more than one job these days. Certainly the more lower paid workers in the economy will very often have 2, sometimes 3 or even 4 jobs. So it is possible for that to continue. The government have made that clear. They've brought that into line effectively with the self-employed scheme, which I know is not part of this discussion this morning, but the self-employed scheme confirmed right from the outset that the claim would be made in relation to previous profits up to a cap, but there was nothing to prevent the self-employed individual, or there is nothing to prevent the self-employed individual from making the claim under the scheme for that subsidy, but nonetheless continuing to work with clients if the work is available. So it sort of brings the two schemes into line. It might be worthwhile me just making one further point, Rob, because I'm conscious this is quite a wide-ranging scheme and there are lots of aspects. We could perhaps focus on the questions after this. But one other area which came into sharp focus, and this may well be relevant to the audience today, is whether or not company directors were able to furlough themselves. Now, there are some scheme issues and there are some practical issues involved in that. If you're a one-man or one-woman personal services company, and you're providing your consultancy services to a client, well, yes, you can furlough yourself, but to be furloughed means you are doing no work, and therefore furloughing yourself, if you're the only person operating through that limited company vehicle, furloughing yourself probably means that the shelf life of your personal services company is not going to be very long, because if you can't do any work, you can't generate any money, and therefore you have issues. You can't service the needs of your clients because furlough means you can do no work. Your client base will probably then move on and find someone else who can do the work for them. So that I think the smaller the company and the fewer the number of directors, the more difficult it is to furlough. In contrast, a client spoke to me last week. They have 6 directors and they're proposing to furlough 2 of them. And they've decided that the jobs that those 2 executive directors do can be, at this point at least, can be shared amongst the remaining directors. So hopefully the long-term viability of the business won't be affected as a result of 2 directors being furloughed. But that then begs the question as to what those directors can do. In fact, what can directors do generally in a company where they are furloughed? Directors, of course, if they're proper directors, they fulfill 2 functions. One is they're employees, so they do work, paid, remunerated work for the business. But as companies' house directors, as office holders, they also have statutory functions. And the question that cropped up last week before the government confirmed the position was, well, if I'm a company director and I fulfill my statutory functions, even though I'm doing no work for the business, can I still claim furlough? And I think most commentators, including me, said, well, we don't see anything wrong with that, because fulfilling your statutory functions, it can be differentiated from providing what would otherwise be remunerated work or service to the company. The government have since confirmed that that is perfectly possible. So statutory directors will be required, because the Companies Act dictates that they have to. They will be required to comply with their ongoing statutory duties as directors of the business. But there is a line to be drawn at the point at which they've discharged those statutory functions. If they then go on and do anything else for the business, which goes beyond simply discharging those statutory obligations, then they'll be regarded as not properly furloughed, and then that would mean that it will be difficult for the employer to claim the subsidy. So I've just touched on 3 or 4 areas there, Rob, which I hope will be helpful, and I'm happy to take any questions.
Really useful. We've got a couple of questions so far. Gary, do you want to start, and then we'll go on to Laura after that? I'll unmute you, Gary. Okay.
Right, thanks. I don't know if hopefully you can hear me. The question I had is that most owner managers, including myself, pay very little salary. It's if you make a profit, you pay yourself on dividends at the end of the year. Am I right in assuming that on the furlough, the dividends are not being counted?
Yeah, you're absolutely right. And again, perhaps I ought to have made that point when I discussed it. You're absolutely right. It'll be a national minimum wage salary or very close to national minimum wage salary, and the preponderance will be by way of dividends on shares. The whole reason that's done is because there's a different tax treatment of dividends on shares. You pay less tax than you would if you PAYE'd it all. That's a payment that's made as a consequence of your status as a shareholder, not as a consequence of your status as an employee. It specifically is not remuneration, and therefore it wouldn't count if you then made the claim for dividends from this furlough scheme.
So how does that differentiate people from being self-employed? Because self-employed people don't pay themselves a wage, they pay themselves from the profits of what they've done.
They do. Dividends are distributions of profit, and there are circumstances where dividends can't be paid. You're not talking to a corporate lawyer here, so I can't give you all of the ins and outs, but I do know that certain requirements have got to be satisfied before dividends are paid. In the circumstance that you're describing, of course, you are treating yourself as employed because you pay yourself a salary, which is based on the national minimum wage or there or thereabouts. So it seems to me to be counterintuitive to say, well, I'm paying myself a salary, but I want to claim that I'm actually self-employed for the purpose.
No, I'm not claiming. I'm just saying, how does a self-employed person doesn't pay themselves a salary, do they? They'll take income from whatever they generate, and that would be classed as their profit if they after everything else is. So there's no difference between dividend payment for which is a share of profit and taking the profit as a whole. I'm not arguing with you. I'm just trying to get a clarification.
No, sorry. I'm certainly not arguing with you. I'm just trying to make the point that they've devised 2 schemes. One is for the truly self-employed, and one is for the employed. And yes, it's correct to say that there might be a rather blurred line between owner managers or personal service company directors who operate in a particular way, and you know, we could open up a whole conversation around IR35 on that, couldn't we? The whole reason IR35 is to be extended is because the government's realised that actually a lot of the payments that are being made through those personal service vehicles are actually disguised remuneration. But I don't think there's much doubt that if you're treating yourself as an employee for tax purposes and you're on a PAYE payroll, you will be entitled to take advantage of the Coronavirus Job Retention Scheme. If, however, you are legitimately self-employed and not on a PAYE payroll, then you'll be able, subject to satisfying the requirements, you'll be able to take advantage of the self-employed scheme. And there may be some people who don't know in which camp they fall, or will want to try and argue that they fall in one camp as opposed to the other. Certainly, if people haven't made significant profits, there's a possibility they might prefer to be in the Coronavirus Job Retention Scheme rather than the self-employed scheme. But you make a very fair point.
Thanks, Gary. We're going to go over to Laura. Laura Feltham's got a question. Laura, I've unmuted you if you want to ask Paul, please.
Hi, thanks for doing this. I just wanted to clarify, to receive the government subsidy, will you need to provide the sort of proof of contract variation and the sort of the paperwork that you discussed? Would that need to be provided to receive the government subsidy?
Well, it's an extremely good question. In the latest guidance note that was issued on the 9th of April, towards the end, there's a paragraph headed "What you'll need to make a claim." And there's a slightly extended list of information here from the previous guidance, which was issued on the 4th of April. And I'm just scanning down that list now. To make the claim, it says you need your employer PAYE reference number, the number of employees being furloughed, their national insurance numbers, their names, their payroll or works numbers, your self-assessment unique taxpayer reference or corporation tax unique taxpayer reference or company registration number, the claim period, the amount being claimed, your bank account number and sort code, your contact name and your phone number. Okay. So in that list, they're not asking for evidence of the contractual variation. Certainly from an employment law perspective, I would strongly suggest that any variation is reduced to writing, right, and is agreed. There is a suggestion elsewhere in the guidance that the relevant paperwork should be kept for a minimum of 5 years, because the government appear to be reserving the right to audit businesses who have claimed under this scheme for a 5-year period. So in order to have a proper, complete and adequate paper trail, certainly my suggestion would be that you do reduce your agreement with the worker to writing, so that there's no doubt as to actually what was agreed, and whether or not you've got to provide it to the government scheme when you make the claim. It appears you don't have to, but certainly if the government, if HMRC take the view that there might have been some underhand dealings or some fraudulent claims being made, I think it's going to be very helpful for you to have that piece of paper that you can wave at them if they knock on your door.
All right, brilliant, thank you.
Just on a related point, Laura, but this may benefit everybody, and it's a point that I didn't make when I was giving the summary, because there are so many things you could cover. One of the other questions that's taxed people over the last few weeks is the timing of the payments. And I think when the scheme was first set up, the clear suggestion the government had given was that the scheme would be a reimbursement scheme. So the payments would first of all have to be made to the employees and then claimed back from the government. Now, interestingly, last week, although it hasn't been confirmed in the latest iteration of the guidance, last week, one of the permanent secretaries from HMRC was grilled by one of the UK Parliament Select Committees. And he was asked the question about payment. One of the MPs was concerned about cash flow, saying that a number of businesses in his constituency would suffer if they had to pay out money to the workers before they were able to reclaim it from the government. And the permanent secretary did say during the course of that evidence, but I'm being careful with this because it wasn't then clarified in the guidance. The permanent secretary did say that in due course, once all the retrospective claims have been paid out, it will be possible for payment to be secured from the scheme before the individual workers are paid. And if that's true, then that will alleviate some of the cash flow concerns that I think a lot of employers have had in relation to this scheme. Yeah. So why did I raise that? Well, I raised it because I thought it might be of interest, but it does also go to the point about varying people's contracts. Yeah. If you're going to vary the contract and put them on furlough, you might want to take the opportunity at the same time to vary the date that they're paid, and possibly even try to tie in your obligation to pay them with receipt of monies from the scheme. Yeah. I don't know how open the workers will be to having their contracts varied like that, but it certainly would be a good opportunity for you to consider including that type of provision at the point at which you agree that they furlough and reduce it all to writing.
Okay. That's great, thanks, Paul. Alistair's just asked a question, Paul, which I don't know whether you'll have the answer to just yet, but just in terms of documentation for furloughing of staff when it comes to sort of annual accounts and audit time, have you got clarity on what documentation is required as part of furloughing, you know, when it comes to audit and year-end time?
No, I don't. What I can say, and again, I'm just scouring through the guidance because there was something about how the payment is treated. Yeah. For tax purposes. Payments received by businesses under the scheme are made to offset these deductible revenue costs. they must therefore be included as income in the business's calculation of its taxable profits for income tax and corporation tax purposes in accordance with normal principles. So that there's a 3-paragraph section in the guidance if anyone's interested. I think probably accountants are going to be better placed to answer that.
We're going to jump on to Lisa from Carrigill's next, who'll be able to just sort of comment on that as well. We've just got a couple of questions, final questions before we do, Paul, if that's okay. I think Stephen Singer, did you want to ask a question, Stephen, to Paul?
Yeah, I'm not sure if this is to Paul or to other members of the panel, but Paul has outlined the limitations of the furlough scheme in terms of you're not allowed to do any work. There's an anomaly, it seems to me, here with owner-managers of small businesses like my own. So we're outside the scope of the self-employed income support scheme, that's clear. There is, in theory, this provision to allow the business to reclaim 80% of what may be a fairly minimal salary, and Paul's gone through that and discussed it with a previous participant. But the question, well, it's an invitation to comment, really, more than anything else, is that the conditions of that, and bear in mind that you know, small businesses such as my own, for example, that might operate from a home office, therefore are not benefiting from business rate scheme or anything of this sort. So pretty much the sole provision for support in the government package may be this furlough scheme, which explicitly requires us to sit on our hands and do absolutely nothing for as long as the current restrictions on movement prevent us from, for example, going and visiting clients and therefore generating any income. So the situation we're in is there's no prospect of doing anything active vis-a-vis clients that may generate any income, but at the same time we're supposed to not be doing anything that will actually prepare us for the time when those restrictions are lifted. In other words, we're being invited to be completely out of touch, to have no communication with our clients, to not do any preparation for the time when business can resume. I just wonder how this can be right when we've explicitly acknowledged that, for example, other people who are furloughed may be continuing with another full-time job. And as we've said, people who are on the self-employed income support scheme could be claiming that whilst at the same time doing some work for their business. Seems to me there's a gap here.
Stephen, you make a very, very valid point, and indeed, you're not the first person to have made this to me. I think that this scheme, whilst it is trumpeted, and I think rightly, as being an extremely generous scheme, there are unfortunately some cracks down which people like you and others will fall, and trying to look at it from HMRC and the government's perspective. And it was very interesting watching some of the evidence given by the Permanent Secretary last week. He made the point that a scheme like this, normally, if the government was going to devise a scheme like this, it would probably take somewhere between 2 to 3 years to properly implement, because there will be a requirement for consultation, there would be feedback, there would be a requirement to tweak the rules. They're doing this as they're going along. This scheme's been devised basically in 4 or 5 weeks. And to have got to the point that they've got to, I mean, I think I have to say, being as objective as I possibly can be, they deserve a pat on the back. But it has unfortunately resulted in a number of individuals falling between the gaps. And the situation you've described is a classic example of that. I think it's right that the government have had to say, look, it is wrong as a matter of principle if we are paying people's salaries because you've decided there is no work to give them, that a condition of the scheme is that there is no work given to them. To me, there's some inherent logic in that, but it means that organisations like yours and similar organisations, where there is usually only one person that could do the work and maintain the client relationships, not being able to maintain the client relationships then has to be traded off against the value of what is a relatively nominal furlough payment. And I think that is just the commercial choice that you and others like you face. Do I take the guaranteed 2,500 and run the risk for a number of months, hopefully not many months, of losing client connections or customers? Or do I continue as I can, maintaining those links, trying to generate business for when we can turn the tap back on, and forego the payment? And it's a really difficult choice, but it is unfortunately a choice you have to make. It's a lot easier when you've got 200 staff. You know, you furlough the staff, which is going to be your biggest overhead, but the managers stay there and maintain the client relationships, keep the business ticking over. Maybe 1 or 2 people wander around the factory to make sure the machines don't seize up. It's a lot more straightforward in a bigger organisation to think about furlough in the terms the government has put it. But for owner managed businesses, or certainly personal service companies, it's a really tricky, difficult choice.
Thanks, Paul. Right, we'll just take one more question from yourself, Richard, if you want to ask Paul, and then we're going to jump across to Lisa Wilson, if that's okay. Richard, if you want to unmute yourself and ask a question.
Hi, Paul. We've taken the view when we've written to all of the staff that we haven't asked for positive affirmation that they've agreed with everything. We've just basically said, we're going to put you on furlough. If you've got any problem with that, please come back to us. Yeah. Is that sufficient from a HR perspective?
Yeah, you see, I think, again, the lawyers in their ivory towers who have got no concept of what's happening on the ground will say to you, well, it's always best if you get someone to positively consent to or affirm a contractual change. Of course it is. But we've all been involved in situations where needs must. And, you know, do you, for example, when you send out a pay increase letter to your staff, do you ask them to sign to confirm that they accept the pay increase? Probably not. You just write to them to say, we're giving you a pay increase. But technically, that is a contractual variation. And the reason no one balks about it is because very few people are ever going to say, no, I don't want the pay increase. So you can treat the notification effectively as akin to the variation. You do run a slightly bigger risk here, of course, but I make the point, or reiterate the point I made right at the start, which is I haven't yet seen any employees at any of my clients, and we've advised numerous on this furlough scheme. I've not seen one person put their hand up and say, I do not want to be furloughed. In fact, quite the contrary. You've had people queuing at the gates demanding to be furloughed. Yeah, it's been a very odd state of affairs. So whilst I have to tell you what the legitimate or the technical legal answer is, the technical legal answer is you should get them to positively affirm. But as with many other circumstances where needs must, saying to someone, this is what we're proposing to do, unless you have any objections and those objections are put to us by a particular date at a particular time, we're going to regard you as having consented to this change. And that is
Thanks,
the
Paul.
best you can do, yeah.
Yeah. Sorry, Mike Wharton, I know you asked a question a little bit earlier, didn't you? So you just want to quickly ask that, Mike, before we move on, please.
Just as per on the text, can a director be furloughed, then work for their own service company on a contract back to their employer from whom they've been furloughed?
Can a director be furloughed? Well, yes, a director can be furloughed, then work for their own service company on a contract back to their employer from whom they've been furloughed. Now, I think I understand the question. What I'll say to you is, or I'll highlight a particular problem that we've seen with the guidance, because everybody in the situation that you face, or the delegates on this call face, will be employers, more likely than not, and will have focused their attention on the specific guidance produced for employers. What lots of people haven't realised is that there is a separate set of guidance notes prepared for employees, which explains to them what they can and can't do in a furlough situation. And interestingly, even though it doesn't appear to be replicated in the employer guidance that was reviewed or amended at the weekend, in the employee guidance, it says you can't work for anybody else whilst you can't work for your employer whilst you're furloughed, but you can work for other people. But there's a caveat. It says you can't work for an associated or linked employer. Now that doesn't find its way, as far as I can see, into the latest draft of the guidance to employers. So all I would say to you, Mike, in response to your question is, if there is an association or link We don't quite know what the government mean by associated or linked. They might mean associated employers, and that's something that's defined in the Employment Rights Act, where there's some element of common ownership between the two businesses. But if the businesses are associated or linked, there appears to be a provision in the employee guidance that says you will be precluded from working for an associated or linked employer whilst furloughed by employer number one. Otherwise, you can work for anybody else. So in your situation, if there is that link, there's a possibility that the scheme rules work against you.
There wouldn't be a legal link though, Paul, would there? Because you'd be working for your own service company that you owned as a shareholder, and you'd be a director of that. And then you would contract your service company back to the firm that you've been furloughed from. So the legal relationship would be between the service company and the other firm, not between you as an employee.
Yeah, so if there's no link, and as I say, I don't really know what the government means by a link, but I've got an idea. If there's no link, then it appears that that arrangement is perfectly permissible.
Okay. Thanks, Mike. Right, we'll leave it there, Paul. Really appreciate your time.
Thank you.
Very, very invaluable information. What we're going to do a summary after this, Paul, and we're going to put your contact details on there if that's okay, so people can obviously just get back in contact with you directly if they do have any questions.
I might need to drop off, Rob, just before the end, so apologies if I've got to do that.
Yeah, thanks a lot, Paul.
Thanks.
Right, Lisa, we'll head over to our head of tax, Lisa Wilson at Cowgills. Lisa, if you again would just do an overview for us, and you know, what you're speaking to clients on currently, and the main sort of points, that would be really useful, Lisa, if you don't mind.
Yeah, of course. So obviously over the last 4 weeks, we've had numerous conversations with clients and done a number of webinars regarding obviously the government measures that they've put in place whilst we've got the coronavirus lockdown. What I would say is that obviously the government have made announcements, and then we've had this enormous backfill by various organisations to try and put in place practical mechanisms by which the government measures announced can become a reality. And like Paul, I'd say that those organisations have done a pretty good job in trying to make something happen in that period of time that would have ordinarily taken a significant amount of time. One of those organisations is obviously HMRC. So like Paul, I've had numerous conversations about furloughing. That seems to be the measure that most people are concentrating on, and they should be, in the sense that actually that's obviously real money back to the company. HMRC, just pick up on a couple of the practical measures. HMRC last week announced that the portal was going to be live on the 20th of April. Now, obviously, the HMRC have built that portal from scratch, because obviously HMRC are used to taking money off you, not necessarily giving it you back. And therefore, what I would say is that portal will be incredibly busy when it opens, and you will need to be patient with it, the same as the HMRC dedicated COVID lines. Initially were incredibly busy. There will be a lot of resource thrown behind it, but I would just say that inevitably there will be some teething problems. So that's the date that we've got in place, the 20th of April. Obviously, as Paul mentioned, there has been a raft of guidance that has been issued over a period of time. So obviously we have the announcements, and then some of the detail comes later. I would hope that where we've still got gaps in our knowledge, such as clarity around the holiday pay and whether it breaks furlough or not, I would hope that that clarity is with us before the portal opens, in order that clients and individuals have enough knowledge to be able to be making valid claims. Now, obviously, that's key. For you guys, not just because you want to understand your position commercially in terms of the money that's coming into the business, but also that you're not making payments to employees that then you're going to have to ask for back if it turns out that it's not the correct treatment. So what I would say to you, from a practical point of view would be to take a reasonably conservative view about the measures, and then if you need to pass more money to employees later on the line, that's probably a lot easier than it is asking for them for money back. What I would also point out is obviously that's one of the specific measures where the government are trying to ease cash flow in organisations and make sure that really while we're in this period, if businesses are struggling to be operational, you know, if operations have been mothballed or substantially reduced during this period, obviously the primary objective of the furlough scheme is to improve the cash flow position of the company or the business. Now, obviously, if you think about that in a logical way, so obviously the provisions have been backdated to the 1st of March, and obviously within that period, there will have been a point potentially where employees become effectively redundant in the business where there's no work for them to do. That will be the start of the furlough period. If we take the best case scenario, and let's say that we go through to the end of May, possibly the end of June, and we're no longer in lockdown and everybody is allowed to go back to work, obviously we will have had a period of furlough where operationally we might not have been doing much, and then we'll have a period of people going back to work, gradually life potentially, hopefully, going back to normal, and then productivity starting again. So when you're thinking about cash flow, I think just be mindful of the fact that we'll have this period where nothing much will be happening, and then there'll be a bit of a hockey stick in terms of everybody getting back to work and actually for us to be producing or providing services, and therefore the strain on cash flow will probably continue for a period of time when we go back to work, because actually it will take it will take a while for normal life to resume, for services to be given, and then for billing to take place and for people to pay. So actually the period where cash flow might be difficult will be longer than just the period where people aren't operational. And I would factor that into your plans when you're looking at the amount of money that you're going to need in the business to get through this difficult time. So obviously, like I said, the furlough is about getting money back into businesses and getting cash flow, easing cash flow. There are obviously other measures that the government have put in place to try and ease cash flow within businesses and within individual organisations. There have been some automatic provisions that have been announced, and these automatic provisions are measures that the government have put in place, so you're not actually paying money out of the business. And then I'll just touch on some provisions that are still there that you can access but actually aren't automatic. So just to start with the first automatic measures, obviously people will hopefully now know that they're entitled to a VAT holiday. So the government have said that anybody that was due to pay VAT essentially in this quarter won't need to make any VAT payments until July. What they are still insisting on is that the paperwork is still in place. So effectively, if you are due to make returns in that period to July, that you continue to make those returns, that your bureaucracy and your administration essentially continues, whether or not a payment is actually due. So that's the first measure that the government announced in respect of trying to keep money in business. The second measure that they announced was with respect to self-assessment and making tax payments on account that would have been due at the end of July. So again, the government have said anybody that was due to make a payment on account the 31st of July of this year doesn't now need to make that payment. So, and obviously there isn't any administration in respect of that payment. So just don't pay it. Now, obviously, that will help cash flow in the business over this period of time, but be aware that obviously that measure is only a deferral. So that money will come due at some point. So overall, don't pay it. And then obviously then come up, if things are due at the end of July, If you feel that you need to stagger payments, then that will need to be under a specific agreement with HMRC. And that leads me on to the second thing that I was going to say to you in terms of the measures that aren't announced but are still available to you. So obviously the taxes where the government have focused their attention on VAT and self-assessment. The taxes that they haven't covered are PAYE and national insurance or corporation tax. And I would say to you that if you need to, if your business is operations have been affected significantly by the coronavirus, I would be looking to see whether it's worthwhile calling HMRC and asking for a time to pay arrangement in respect of your PAYE and national insurance, and also on your corporation tax. Now, historically, HMRC haven't been very willing to agree to payments on account for things like PAYE and corporation tax. But at the moment, because the helpline is very busy and because at this point in time, government look to be doing everything that they possibly can to try and ensure that businesses survive during this period. If you call HMRC and ask for a time to pay arrangement, it is our experience and the feedback from our clients is that it's a lot easier to agree now than it's ever been. So you need a lot less information. You need to explain to them how your business has been affected by the coronavirus, and it will be possible to agree either a deferral of the tax that you may be due to pay during this period, or a payment arrangement that could cover payments being made on the drip. And I would encourage you to do that now. The reason being that the appetite for HMRC to agree these payment plans is very good. And this might not be the case in a couple of months' time when you realise actually you need to undertake these measures in order to retain cash flow in your business. So that would be something that I would recommend that you look at, cash flow modelling, to make sure that you have enough cash in the business over the period of lockdown, or where we're reduced operationally. Think about the period where we come back to work, where we are hoping to get back to a period of profitability, and what the drag on the cash will be at that point. If you can reduce tax payments going out of your organisation, then do. And I've also had large clients where they've made payments on account for their corporation tax, where they've been successful in asking HMRC for those payments back. And obviously that's money back into the company, that's refunds from HMRC, and again, that obviously is going to help cash flow. The other measures that we've been looking at for clients is where there might be opportunities for them to make claims. So as a business, Kegels have a large R&D portfolio. So we help clients who undertake R&D, and those are either service companies or manufacturing companies, whereby they undertake R&D as part of their regular activities. And it might be that on a regular basis that they make claims. So we're obviously helping clients as we would ordinarily in order to be making those claims, but also where clients might have or have had large R&D spend at the beginning part of their accounting period. Ordinarily, to make an R&D claim, you need to wait until the end of the accounting period in order to do a set account and file your corporation tax return. And it's only at that point that you're able to make an R&D tax claim. So what some of our clients have done, because their R&D tax claim is very front-loaded, we have looked to shorten the accounting period. And as long as there are no commercial reasons why you wouldn't do that, it might be advantageous for you to shorten the accounting period in order to be able to make that claim quicker than you would ordinarily be able to do. So effectively accelerating cash payments back to the corporate. The other thing that we do a lot of as well is our capital allowance claims on buildings. So again, if that's not something that you've looked at in the past, or if that's something that you're in the process of doing, again, look at accelerating payments, look at measures whereby you might be able to get cash back into the business. So really, you know, not just, so when you're considering all of these measures, look at the cash that's available from the government, so the furlough scheme. I've mentioned that obviously the portal is due to be open on the 20th of April. Obviously, the world and his wife will be trying to access that portal on that date. So what I would say to you is just be patient, but have all the information ready, be prepared. Just to follow up from what Paul said as well, I would be very diligent in terms of keeping the information that is required. I would imagine that after this period is over, HMRC will be undertaking audits of the information that you will be required to keep. So I'd be very diligent in collecting that. So that's information, so that's cash into the business. Again, stop cash going out of the business. So think about your cash flow, potentially do some cash flow modelling to understand the sensitivities around that. And if it is possible, and at the moment it seems like it's very possible to get agreement from HMRC regarding time to pay arrangements, I would be asking for them now. Even if you don't feel like the need is that you've got a requirement now, but you might do in 2, 3, 4, 5 months' time, I'd get agreement now because they're very susceptible to say yes. And then also I'd look at making claims about what's happened the last 6 months to 12 months. Is there any R&D claims? Are there any capital allowance claims that would increase the cash flow in your business? Have you made any payments out that you can, or are there any payments that you can accelerate? And that's really what we're advising clients on a practical point of view.
Yeah. Fantastic, Lisa. Really, really useful. Thank you very much. Just conscious of time. Again, what we'll do, we'll put Lisa's details on there, and any questions that you have following today's forum, then please just contact Lisa directly and she'll be happy to help. We'll move on to Ben Day, who is Head of Business Funding at Cowgills. In touch daily. Even more so, Ben, with the banks at the moment. So again, if you could just give an overview of what you're finding and what the banks are saying and what our clients are saying, that would be great.
Yeah, hi, morning everyone. I guess sort of going on from what Paul said actually with regards to the furlough scheme, in that they're almost sort of doing it and evolving it as time moves on. Exactly the same with the CBIL scheme, the Coronavirus Business Interruption Loan Scheme. It was made available or started on the 23rd of March. It's been open 3 weeks now. However, when I was speaking to bank managers on the 23rd, 24th, even the 25th, it still hadn't trickled down to the banks. The government announced it. Everyone then went to apply for the banks, and the banks were sort of still playing catch up. As time has moved on, banks are obviously dealing with an awful lot of calls. They're getting a kicking from the media as well. But personally, I think they're doing a good job in trying to manage the situation as best they can. I was listening to a lady from the RBS who sort of said their call centres normally have 3,000 calls a day. They're currently receiving 25,000 calls a day. So it's very difficult for the banks to deal with everyone because they're getting, they've got 180,000 applications across the board, which they are starting to work through. I had a client this morning who emailed saying that from start to finish, 10 days he put his submission into his bank and he's just received the money now, which, like I say, was 10 days. So the banks are starting to move. As I say, I'm often one to kick the banks previously, but I think they are doing a very good job. What I tend to find helps from the client's perspective really is, rather than going to your bank and going, what can you do or how can you help us, is actually more going to the bank and with a plan, sort of saying, look, I need X amount of money to get us through the next 3 weeks or 3 months rather, and then giving an example, showing to them how business was trading beforehand, what the effects of the coronavirus has been, and then ultimately, showing how much you need and why you need it. And as I say, cash flow forecast, as I say, that Lisa mentioned earlier, is a great way of showing that, especially as the banks also want to know what you've done to cut costs, whether that's furloughing people, asking for rent holidays, repayment holidays, etc. But as I say, it is a constantly evolving thing, and I do expect it to be quicker and easier as time goes on, really. But the first port of call should be to your existing bank and providers, and then failing that, please do get in touch, really.
I think the initial frustration and backlog, Ben, was that obviously the government introduced a scheme and the banks were wanting to find out the finer details of it themselves, weren't they? So I think there was quite a lot of business owners and clients of ours that were very frustrated, weren't they, initially for the first few days. But I think as that example, as you said before, one of our clients in the recruitment sector that has had a 10-day turnaround from NatWest, I think it was, that clearly shows that they are now getting hold of it and able to act a lot quicker, aren't they?
Yeah, exactly. And as I say, I mean, it's very, they're in a very difficult position, really, because whilst they are, whilst the government have said, look, we're guaranteeing the money, or guaranteeing 80% of it, actually they're guaranteeing 80% of any shortfall. So whatever happens, if the business loses money, then the banks also lose that money. Yeah. But similarly, I think that they've got a responsibility to UK taxpayers, really, as well, because if there is if there's a shortfall, yes, the banks pick up 20% of that shortfall, the government pick up the 80%. Ultimately, I've no doubt that it'll be us picking up that, the UK taxpayer picking up that 80% as well. So, when you've got businesses that probably weren't, if they're honest with themselves, were probably trading insolvent beforehand, they shouldn't really be requesting money, and then when they do get declined, giving the banks a kicking, really, because they need to be responsible lenders more than anything.
Absolutely. And if we just bring Sam into the conversation, Sam's corporate finance partner at Cowgills, Lisa's made a couple of very, very valid points that it's not all about cash flow now and the business hopefully surviving over the next couple of months, however long we're in lockdown for. It's actually also coming out the other side. And Sam, if you just sort of want to comment on that.
Yeah, absolutely. So what we normally do in corporate finance is just to focus on protecting and maximising shareholder value for people. And I don't think that job has changed at all. It's just working out for business owners at the right point when they can achieve that exit and sell the shares, which for most people is the most valuable asset they have. We've been working with, currently mainly within our existing client base, but trying to help people bridge the gap between, we've had a period of short-term cash requirement, we've bridged through that, and then we need to come out on the other side of it. And what's it going to cost, or what capital are we going to need to restart our businesses? And for a manufacturing business, which is a long-term client of ours, his working capital has probably gone from needing to have 60 days worth of working capital to 250 to get that business restarted again. And that's a huge capital investment that he's not going to get anywhere else. So part of the forecasting, part of the planning, and his application for the CBILS loan has been about putting that development capital into his company. I've got other clients that are highly internationalized businesses with a supply chain based out in China, who have had massive issues with the supply chain, but whilst it's open, they need to flip on the switches and buy an absolute shed load of stock so they can trade out through the poorer times. It's a kind of tabletop games business. Actually, business is quite good at the moment with a lot of people being at home. But again, it's all about what capital do we need to be able to grow our business on the other side. So the work that we've been doing with CBILS is more focused on the longer term picture. And actually, if you understand kind of how the legislation and all this government support has been structured, it's quite clear that there's lots of short-term cash support for businesses that we've all talked about earlier on today. But then there's also some longer-term support, and really a key part of CBILS and all the bank managers I talk to, the ones that they are kind of keenest to back and to be supportive of, are those that have a long-term plan to build up the value of the company, and to therefore prove that they have got a real development capital need, and it's not just plugging a short-term hole. And if you think logically for a bank, plugging a short-term hole is not really what they're designed for, perhaps with an overdraft, but really that's a very difficult place for them to be. They want to put, term loans into companies that are going to grow the value of the company and be able to afford the repayments. So we've been preparing short-term cash flow models for people, 2 to 3 year forecast models, and they've been helping clients to write a business plan to go in. And every time we submit that to a bank, the feedback has been absolutely fantastic, because it's an oven-ready credit paper as opposed to a request. But it's sort of important to note that typically we're talking for a loan value in excess of £500,000, that level of work is probably required. If you're sort of in the, maybe we'll call it sub 250, I think it's a lot simpler process. And all of the people we've heard that have quickly got their capital in have either been highly leveraged already. So if the bank didn't forward them some more money, it would cause an issue on the other loans, which could go into default. So therefore, I suppose they're kind of already caught up in that, or they've been looking for a relatively modest size loan, and those seem to be coming through relatively quickly. So depending on where you sit on that spectrum is kind of how you should approach it, but absolutely thinking about the long term. And if you want to speak to me, or in fact anyone in our team at any point, just kind of a general chat about what these schemes could look like for your business and kind of how you should approach it, we're very happy just to invest some time. We obviously won't charge you for that, just to have a good discussion and try and give you a bit of guidance and kind of point in the right direction if that's helpful. But if you do require some more detailed work, then we've got a fairly decent sized team that are here to support anyone that requires it.
That's great. Appreciate that, Sam. Thank you very much. We'll just finish off. I'm just conscious of the time. We'll just finish off with Nick Briley from our business recovery team. The guys at the moment are, as you would expect, working with a lot of businesses just on general straight talking advice and some turnaround advice that they may need currently. So Nick, if you just want to sort of give an overview of how you're helping businesses and directors' responsibilities during these times, that would be great, just to close.
Yeah, sure. I'll be brief. Morning, everyone. Conscious time, so yeah, I'll keep it as quick as possible. Probably a couple of key points, which one has already been discussed by Lisa. I think time to pay arrangements, whilst historically revenue have been looking at them from a means tested perspective, now we're just seeing that clients are able to ring the revenue, give them the information about how their business has been affected by the virus, and they are being granted with time to pay either deferred corporation tax or pay-as-you-earn liabilities, or instalments at a later date. So that's one change and one thing that has helped, I think, quite a lot of clients recently. The other point that I would probably stress at the moment is directors' duties. So normally when a company goes into a formal insolvency process, we would look at the conduct of the director and what went wrong with the business. I suppose it's key now during these times where a business isn't trading that the directors certainly protect the stakeholders and try and protect the status quo as best they can do under the circumstances. And whilst there has been an announcement there's been a relaxation in the wrongful trading claims that a liquidator could potentially bring against the director at a later date, when we're looking at this period of trading, I would stress that, please do be sensible with your decision making. Try and bear your creditor's position as well as your own and your shareholders' position in mind when making any business decisions. And again, onto time, if anybody's got any questions surrounding directors' duties or just wants to have a chat generally about their business and the position, more than happy to have a chat on the phone or on Zoom, no problem at all.
That's great, thanks, Nick. I mean, I'm sure there'll probably be a multitude of questions that people think about when the meeting finishes. And as I said, the summary document will be available with everybody's contact details on, so we'll send that round. And also the recording will be available as well. I know a couple of people have mentioned that in the chat questions, so we will make the recording available after, which you'll send on a link if there are any points that you just wanted to skip to. But as I said, the message is there. Please feel free to get in contact. Absolutely no issues. We'll be as helpful as we can. And in the meantime, I wish you all the best with your businesses over the next few weeks, and you know, all take care. Thank you very much indeed for joining. Thank you.